students, now we will be dealing with a chapter relating to forest conservation and law. The basic objectives of this lesson are to understand the Forest Act 1927, to understand the need for Forest Conservation Act 1980, to understand the important forest policies and their amendments, to understand the Forest Rights Act 2006 and its necessity. Forests are the most valuable natural resources available to the mankind on planet Earth. The saga of deforestation in the developing countries on account of rising population and consequent poverty has attracted global attention of scientists, environmentalists, and lawmakers. Various forests are essential source of livelihood for the poor and marginalized sections of the society. They provide lavish items for the rich. A good forest is a resource base for all other life-sustaining resources. Forests occupied central stage in the global negotiations after the Rio Summit in the year 1992, when the future of our environment and development was linked to the sound and efficient management of forest resources. Though the people since time immemorial managed forests, the modern forestry practices started only during the last 200 years. Let us deal with the protection of forests during the British period. The British government has recognized the need of the forests in India. The Forest Charter of 1855 was the first attempt by the British Indian government in the direction of forest governance. The Charter of 1855 was followed by the Indian Forest Act 1865, which was amended in the year 1878 and then again in the year 1927. The 1865 Act empowered the government to appropriate any land covered with trees. According to the 1878 Forest Act, forests were categorized into three types: reserved, protected, and village forests. Let us now deal with Indian Forest Act 1927, the most important forest related act. The Forest Act deals with four categories of forests, namely reserve forests, village forests, protected forests, and private forests. The basic objectives of the Indian Forest Act 1927 are, according to the preamble of the Act, which states that the Act seeks to consolidate the law relating to forests, the transit of forest produce, and the duty leviable on timber and other forest produce. The first category is reserve forest, the most restricted category, which is the reserve forest. These forests may be constituted by the state government on any forest land or wasteland which is the property of the government, or on which the government has proprietary rights. The next category is of protected forests. The state government is empowered to constitute any land other than reserve forests as protected forests, over which the government has proprietary rights. In protected forests, the government retains the power to issue rules regarding the use of such forests. The next category is of village forests. This is the third classification in which the state government may assign to any village community the rights of government to or over any land which has been constituted as a reserve forest. The state government may also make rules for regulating and management of such forests. The government must survey the rights and claims of private persons in forests being considered for protection, but may declare the forest area a protected forest pending completion of the survey. State governments may prohibit certain activities such as grazing, cultivation, charcoal burning and stone quarrying, and also allow a way through the forest area, and may also provide access to water resources present in the forest area, or may permit the forest dwellers and villagers to take minor forest produce for their basic requirements. The power to levy duty on timber and other forest produce and the regulation to timber and other forest produce in transit vests with the state government respectively under the Act. There are certain penalties provided under the Act. A person who commits any of the offences like cutting of trees, stripping the bark or leaves of the trees, set fire to such forests, or permits cattle to damage any tree shall be punishable with imprisonment for a term which may be extended to 6 months, or with a fine which may be extended to Rs 500, or with both. Any forest officer without an order from the magistrate or a warrant can arrest a person against whom a reasonable suspicion exists. Any forest officer or police officer who vexatiously and unnecessarily seizes any property on pretence of seizing property liable confiscation under this Act shall be punishable with imprisonment for a term which may extend to 6 months, or with fine of which may extend to 500 rupees, or with both under section 62 of the Act. Whoever knowingly counterfeits upon any timber or standing tree a mark, or alters, moves, destroys or defaces any boundary mark of any forest or wasteland to which the provisions of this Act are applied shall be punishable with imprisonment for a term which may extend to 2 years, or fine, or with both under section 63 of the Act. The district magistrate or any magistrate of the first class specially empowered in this behalf by the state government may try summarily under the Code of Criminal Procedure 1898 any forest offence punishable with imprisonment for a term not exceeding 6 months, or fine not exceeding 500 rupees, or both under section 67 of the Act. Approximately 4.3 million ha of forest land diverted during 1950 to 1980 for non-forest purposes. India's first forest policy was initiated in the year 1952. This led to the Forest Conservation Act of 1980 and also its amendment in the year 1988. Let us deal with a new act, Forest Conservation Act 1980, and its basic requirement. In 1980, with the introduction of the Forest Conservation Act, the central government reasserted some of its control over forest-based resources. It was enacted for providing a higher level of protection to the forests and to regulate diversion of forest lands for non-forestry purpose. The objective of the Forest Conservation Act was enacted with the twin objectives, which was restricting the use of forest land for non-forest purposes and preventing the de-reservation of forests that have been reserved under the Forest Act 1927. The salient features of the Forest Conservation Act are as follows. The Act places restrictions on the power of the state government of the use of forest land for non-forest purposes. The Act provides for the constitution of advisory committee to advise the government with regard to the grant of approval by the central government or any other matter which is connected therewith. The conservation of forests which may be referred to by the central government as per section 2 of the Act all ongoing non-forest activities within any forest in any state throughout the country without prior approval of the centre must cease forthwith after this act is passed. The contravention of the provisions of this act could entail simple imprisonment, which is extendable to 15 days. The act also provides for punishment of offenders from the government departments, including head of departments and authorities. However, these persons can escape criminal liabilities if they can prove that the offence was committed without their knowledge and they had exercised all due diligence to prevent the commission of such offences. Under the Forest Conservation Act 1980. The National Forest Policy 1988. The National Forest Policy 1988 envisions people's involvement in the development and protection of forests. The requirements of people living in and near forests for fuel wood, fodder and small timber are to be treated as first priority, and forest communities should be motivated to identify themselves with the development and protection of forests from which they derive so many benefits. The policy goes on to state that the principal aim must be to ensure environmental stability and maintenance of an ecological balance which is vital for sustenance of all vital forms. The need for amendment of 1988 to the Forest Conservation Act 1980. In the year 1988, the Forest Conservation Act 1980 was amended to stop the use of forest lands for establishing plantations by private parties. In keeping with the 1988 Forest Policy of Forests, which was being managed for the needs of the forest dependent communities. The 1988 amendment mandated that wood based industries should source their raw material from farmlands. However, the amendment does not prohibit the forest departments from undertaking plantations, which is still prevailing in India. However, in the year 1988, the Act was further amended to include two new provisions, where it sought to restrict leasing of forest land to private individuals, authority, corporations not owned by the government, and also restricting clear felling of naturally grown trees. Let us deal with the impact of Forest Conservation Act. During 1950 to 80, the rate of diversion of forest land for non-forestry purposes was 1,50,000 hectares per annum. After enactment of the Forest Conservation Act 1980, the rate of diversion of forest land for non-forestry purposes came down to about 35,000 hectares per annum, which is a positive sign towards protection of forests and its valuable resources. There are some limitations to the Forest Conservation Act. The Act has failed to attract public support because it has infringed upon the human rights of the poor native people due to lack of awareness among the people of forest laws and their rights. Forest dwelling tribal communities have a rich knowledge about the forest resources, their values and conservation, but their role and contribution is neither acknowledged nor honored. The situation is made the Government of India think about the human rights of the native people and their support in conservation of the forests, which could only fulfill the objective of sustainable development and regulate the degradation of forests. Hence, they introduced the concept of joint forest management for the purpose of maintenance of equilibrium rights of the forest dwellers. The concept of joint forest management in India It was introduced in the year 1990, which witnessed an unprecedented move by the central government, resulting in the issuing of a circular on joint forest management, which recognized the role of forest communities in the management of forests. The said circular attempts to involve people by providing minor forest produce as well as benefits that would accrue due to harvested timber in case of the village forest communities. The Ministry of Environment and Forests, Government of India, has created a joint forest management cell, monitoring cell, created in response to a growing realization that public participation through the joint forest management program is crucial for effective protection of forests in the country. But still, the rights of forest dwellers were not recognized to a large extent, and hence an act towards recognizing the rights of the forest dwellers was envisioned by the Government of India, and the Forest Rights Act came into being. The Scheduled Tribes and Other Traditional Forest Dwellers Recognition of Forest Rights Act 2006. The Forest Rights Act is considered to be a bold legislative attempt by the Government of India to synchronize forest management and its governance with the help of forest dwellers. This enactment was made to recognize and vest forest rights and occupation on forest land with forest dwelling scheduled tribes and other traditional forest dwellers. The Act envisages sustainable use, conservation of biodiversity, and maintenance of the ecological balance to strengthen the conservation regime of forests and ensure the livelihood and food security of forest dwelling scheduled tribes and other traditional forest dwellers. The Forest Rights Act basically envisages a three-step process to recognize the rights of forest dwelling scheduled tribes and other traditional forest dwellers who have been living in such forests for generations. It includes initiation of claims, verification of claims, and the vesting of rights upon verification. The claim can be individual forest rights or community forest rights. The forest conservation and judicial response in India. The following discussion focuses on the judicial response to the protection and conservation of forests in India. It may be noted that the most important judgments only have been selected for the purpose of analysis. The first case is relating to Ambalal Manibai Patel and others versus State of Gujarat and others. These two appeals center around the question of how to strike a balance between the need of exploitation of the mineral resources lying hidden in the forests and the preservation of the ecological balance and to arrest growing environmental deterioration. When the appellant's lease was about to expire, the appellant applied for renewal of lease as per Rule 18 of Gujarat Minor Mineral Rules 1966. The appellant's lease was rejected by the Assistant Collector on the ground that the land fell under the reserve forest area and hence the Forest Conservation Act 1990 applied to this said forest. The appellant contended that the said land was under the control of the Industries, Mines and Power Department and thus the Forest Conservation Act 1980 does not apply. The court held that the enactment of the Forest Conservation Act 1980 was in the recognition of the awareness that deforestation and ecological imbalances as a result of deforestation have become social menaces and further deforestation and ecological imbalances must be prevented. Next case, a very important case, is relating to Banwasi Seva Ashram versus State of Uttar Pradesh. A letter from Banwasi Seva Ashram was registered under Article 32 of the Constitution. The main grievance of the petitioner was that Adivasis and other backward people were using forest as their habitat and means of livelihood. Part of the land was declared reserve forest, and in respect of other part, acquisition proceedings were initiated, as the government has decided that a super thermal plant of the National Thermal Power Corporation Limited was to be located there. The Supreme Court gave detailed directions safeguarding and protecting the interest of the Adivasis and backward people who were being ousted from their forest land by the National Thermal Power Corporation. The court permitted the acquisition of land only after NTPC agreed to provide certain facilities to the ousted forest dwellers. Another important case is of rural litigation and entitlement Kendra versus State of Uttar Pradesh. This is also famously known as the Dehradun Valley case. In this case, the court appointed an expert committee to advise the bench on the technical issues, and on the basis of the report of the committee, the court ordered the closure of number of limestone quarries. Another case relating to forest conservation is Rural Litigation and Entitlement Kendra, which is an NGO, versus State of Uttar Pradesh. In this case, the Supreme Court allowed a mine to operate until the expiry of lease as an exceptional case on undertaking by the leasee that the land taken on lease would be subjected to afforestation by him. Consequently, when it was brought to the notice of the court that the lessee made a breach of the undertaking and mining was done in most unscientific and uncontrolled manner, causing damage to environment, the court directed the lessee to pay rupees 3 lakhs to the fund of the monitoring committee, which had been constituted by the court to supervise the afforestation program to be undertaken by the lessee. A series of very important rulings from the Supreme Court of India came in the cases of T.N. Godavarman Tirumulkpad versus Union of India. This was the case actually relating to the protection and conservation of forests, particularly the illegal felling of trees. In this case, the Supreme Court issued interim direction that all the ongoing activities within any forest in any state throughout India without the permission of the central government must be stopped forthwith. The court issued directions to stop felling of trees in other states such as the state of Jammu and Kashmir, Himachal Pradesh and Tamil Nadu with a view to protect and preserve the forests. The series of the case in 1997. In this case, some of these directions were modified by the Supreme Court subsequently. And in another series of this case, in these cases, the court called for the comprehensive statement of all the states about their past activity and their future program to tackle the problem of degradation and degeneration of forests. In another case of the same series, the court opined and differed with the perception of the Ministry of Environment and Forests was that even though the proliferation of wood-based industries has been the main case of degradation of forests in the northeastern states, considering the extent of forests and dependence of the local people on the forests resources in the region, it is neither feasible nor desirable to ban completely whether the timber trade or running of the wood-based industries. Another series of this case. In this case, the Supreme Court appreciated the perception of the Ministry of Environment and Forests and issued certain further directions for protection and preservation of the forests. In another series of the case, the Supreme Court directed the state governments and its functionaries to refrain from cutting any tree or trees till further orders. even if it was found to be a deceased tree. According to the report, the states of Andhra Pradesh, Madhya Pradesh, Assam, Manipur, Nagaland, Orissa and Meghalaya were the main defaulters. In another series of this case, the Supreme Court, on the basis of various reports and affidavits, noticed that the deforestation and illicit mining has caused immense damage to the environment, and hence directed that an independent commission comprising of a police officer not below the rank of an Inspector General and Director, Indira Gandhi National Forest Academy, Dehradun, be constituted. Let us now deal with the conclusion for the forest laws. It's very difficult for any law to control the menace of deforestation, but the aptitude of ecocentrism needs to be developed by the people towards nature. Ecocentrism institutes a nature-centered environmental ethic where humankind is not placed above or beyond the environment, but is embedded within it. We need to acknowledge and appreciate our interdependence with a biotic or physical environment and how our actions affect ecosystems and the biosphere's functioning. Ecocentrism cares less about individual animals or organisms and more about the health and balance of ecological communities and ecosystems. We have been blindly following the course of anthropocentrism, which views humans as the center of ethical concern. While the environment is often seen as a usable resource, there for our personal exploitation. But it's high time that human beings understand that that they are also part of nature, and hence they need to play a pivotal role in protection and conservation of environment, as it's their duty and need of the hour also. In order to put an end to illegal deforestation, contractors should be replaced by institutions such as tribal cooperatives, labor cooperatives, government corporations, etc. Undertaking integrating area development program to meet the needs of the tribal economy in and around the forest areas, including the provision of alternative sources of domestic energy on a subsidized basis to reduce pressure on the existing forest areas. Dear students, I hope you enjoyed the information provided in this session. In the next session, we will be dealing with the other most important biodiversity area related, which is wildlife protection and law. Thank you.